5 minutes for questions.
Thank you, Mr. Chairman. I have to tell you all, and I appreciate all of you being here, that I think part of the problem is that we have a clash of two worlds, the legal world and the medical world. Because when I look at the authority granted to the FDA under the code, with the exception of the advertising overreach, which was stricken down, there's plenty of authority already there to get to every problem that you all have raised today. And that's my concern. And I asked the doctor earlier, and she was very kind, that, this happened, the Supreme Court case came down that dealt with the Ninth Circuit in 2002. Where was the request to Congress to clarify? Because the only clarification is that the rest of the authority granted, with the exception of the advertising provisions, should have been reenacted by Congress. Now, can we tweak it a little bit and make it a little bit better? I'm sure we can. And I'm certainly that we will work on that, because none of us want to see this problem happen again. But I heard one of the witnesses, and I don't remember which one now, say that they understood that there had been problems, getting the records and getting into things. And in fact, I think because the medical world and I was a courtroom attorney, and so maybe it's a little different, not just attorneys, but courtroom attorneys, they see things differently. So I asked legal counsel, who was here at a previous hearing for the FDA, do you have any trouble getting warrants? Well, and I expressed that my opinion always was, as a defense attorney, criminal defense attorney, that the government didn't have too much trouble getting warrants. He said that wasn't my experience. I asked him to get me information. Yesterday we received that information, and sure enough, the FDA cannot point to a single example of where they requested a warrant where they were denied that warrant. So while the common belief is they have a hard time getting this information, the data would indicate otherwise. I also asked, how long does it take you to get the warrant? And they said in the most recent administrative warrant we sought for a pharmacy, 10 days passed between when the refusal was encountered and when the warrant was signed by the magistrate judge. I've got to believe that if, as somebody said earlier, the blinking light, the red light warning had been going off for years, that if instead of being timid and being afraid of the law, the medical folks had burst in, as often police officers have to do. If they think somebody has a DUI, they may not win the case in the end, but they get that person off the road, at least temporarily, to see what's going on. That's what should have happened in this situation. Would you agree with that, Mr. Harmison, that that's probably what should have happened instead of coming in and trying to do a rewrite of the law?
Yes, sir. If there's public safety at risk, the State Board of Pharmacy absolutely has the power to come in and say, wait a minute, you're shut down.
Yeah. And I think that the guidelines that were worked on, never fully finalized, but that were worked on in the draft guidelines of August of last year that we didn't learn about until March of this year, make that clear as well, because it goes through, and when it talks about distinguishing between, as you all have called them, different names, large-scale producers or production of compounded drugs, large-scale manufacturers. I think they're manufacturers, and I said in one of the earlier hearings, I can call myself the Duke of Earl if I want to, but that doesn't mean I'm getting diplomatic immunity. And that's where I think we run into this problem. But when they did that draft, they said when you're looking at whether or not somebody is, doing a compounded drug product that qualifies for the exemptions, they came up with 10 guidelines. And they're all significant and important, but I noted with interest 2 of those. Number 8 says the licensed pharmacist or licensed physician does not compound regularly or in inordinate amounts any drug products. Number 10 says that you should have a memorandum of understanding with the states so that you can work out these areas that aren't clarified. And in a state where they've not entered into a memorandum of understanding, the pharmacist shouldn't be sending to another state more than 5% of the total prescription orders dispensed or distributed by such pharmacy or physician. These seem to me to be reasonable restrictions, and it makes the definition that I think each one of the witnesses here today is looking for, distinguishing between the traditional pharmacy that's doing some things for their patients and their customers and these large-scale manufacturers who are, in fact, in my opinion, they're not compounders in the traditional pharmacy sense, but they are, in fact, manufacturers. I look forward to trying to make sure that we clarify some of that, because I do think that part of the problem is not having some street lawyers at the FDA who know that sometimes you got to go in and kick the courthouse door down and say, here's what we're doing. And when the judge sees the risk to the public, he'll say, okay, I'll sign the warrant. Okay, we'll shut them down, at least until we can find out whether or not they are a risk to the public. I think the authority already exists for that. I just think there's been some timidity in the legal department at the FDA. And when you talk about registration, when you look at the rules in Section 510 of the Act, I think it's pretty clear that unless you're a small-town pharmacist, you're supposed to be registering anyway. Does anybody disagree with that? Dr. Gottlieb, do you disagree with that?
No, 510 has a requirement for registration. I think 503A actually lays out some criteria to try to distinguish, these illegitimate compounders from the legitimate ones. So the language does exist, and even 503A could be better interpreted in regulation, but I think the compliance policy guide, which you just quoted, is a very good start for that.
Yeah. I think they did a nice job in that guidance. I'm not going to say I would agree with every word of it, but most of it's pretty good stuff, and it indicates the FDA had the authority to move forward even under the rules that they now say they don't have the authority to do. With that, I see my time is up, and I yield back, but I do appreciate all of y'all staying through 2 vote series on a long day. Thank you.
Chair, thanks.